Trev, I appreciate that. Next, let me turn to Elenor Wade. Good morning.
Good morning, Chairman Allen and members of the committee. My name is Elenor Wade, and I'm a supervising attorney in the Prisoner and Reentry Clinic at the George Washington University Law School. I'm here today to do two things. First, I want to simply echo the testimony of our friends and our colleagues at the Council for Court Excellence, the DC Justice Lab, and the Collateral Consequences Resource Center, and others for supporting a massive overhaul of our current law and vastly expanding eligibility for sealing. And to us, that includes passing the Restore Act. Second, I want to raise the very important issue of access to justice, which is separate from the basic eligibility rules in any law the council might pass. So what is access to justice? When we talk about access to justice, what we're describing are all of the procedural steps along the way, along that path to achieving whatever justice the law is supposed to provide. And we're talking about whether those steps, and some might call them obstacles, promote or discourage the ultimate goal of the law. And here, the justice sought is clear. It's the clearing of a person's record, whether that be to restore a sense of personal dignity or to just get a job or an apartment. But before that justice can be realized, what does a person need to do? As you've heard from other witnesses, and as you know, the current law requires far too much, even when someone has the assistance of an attorney. For the past several months, our students in the GW Law Prisoner and Reentry Clinic have conducted research on access barriers to felony conviction sealing around the country. We did so because felony conviction sealing specifically is the most meaningful remedy to our clinic's clients, who are either currently or in prison or are now returning citizens seeking to rebuild their public life after sometimes decades of incarceration. Notably, the district was not part of our review of access barriers in these laws because, as you noted in your opening remarks, Chairman Allen, our current law only allows sealing of a single specific felony, and at this time provides no meaningful relief to people with felony convictions. But from our students' work, we've been able to identify the most common access barriers to sealing, and we hope you'll consider these in passing any new law that relates to criminal record sealing and expungement. Access barriers include complicated statutes with confusing eligibility rules, filing fees, expensive service of process requirements, and court procedures that essentially require the assistance of an attorney to navigate. Access barriers also include steps that require massive time and money investments for eligible individuals. Every single time a person is sent to a different office to pay for or request a record, or has to fill out a complicated form, or has to painstakingly search, often to no avail, for a plain explanation of how the law works, that takes time. And whether or not someone can make time to seek the remedy, every additional step is frustrating and it's discouraging, and it deters people from making full use of the law. So specifically, we have some recommendations for how the council can promote access to justice if you seize this current opportunity to rebuild our sealing law from the ground up. First, the law should be written in plain language. This is one of the reasons we're encouraged to see Councilmember Henderson has introduced the Restore Act and why we express our support for it today, because it's no secret that the district's current sealing law, such as it is so complicated that it often requires an experienced attorney just to determine if an individual is eligible. The law should also clearly inform petitioners of any rules about service of process, filing fees, and what to expect when they get into court. Second, service of process, both prior to and after a petition is filed, should be handled by the court. In a record sealing case, the court is in a unique position to do this because it has much easier and cheaper access to the relevant parties, usually prosecutors and police agencies, than petitioners. Third, filing fees should be low if non-existent. Filing fees, even those the council might consider nominal, are very serious barriers to access to justice, and they compound the untold costs of involvement in the criminal legal system. And fourth, the council should use any new sealing law to direct the court to create accurate and easy to use form petitions and instructions for sealing cases. So we encourage the council in considering any new sealing law to put themselves in the position of a person without specialized legal knowledge and ensure the law is written for that person. No criminal legal system reform is complete without a comprehensive sealing law. The pipeline into the criminal legal system is wrought with injustice, particularly based on race, and this is especially apparent here in the district. And a robust sealing law that promotes true access to justice and access to its remedies is a pipeline out of that system. And we welcome any opportunity to work with the committee and the council to make that a reality. Thank you, Mr. Chairman.
Absolutely. Thank you.